Yes, I'm talking to Alan Collins on the phone following a little item that Channel TV put out a week or so ago. Alan Collins had recorded a piece, and it's about delay. The prescription, I think, is the official term, isn't it? Prescription making people who suffered sexual assault many years later want to bring a claim. You can explain, Alan. What is the actual scenario we're looking at?
Well, what we're talking about is adults making claims to Jersey's Criminal Injuries Compensation Board to get compensation in respect of the physical and psychiatric injuries that they've suffered as a result of being sexually abused as children. And the problem that they encounter is that there's this 3-year rule that says you're meant to apply within 3 years of the crime being committed. Now, lots of schemes have these sorts of rules, otherwise it'd be a sort of free-for-all. You've got to know where you stand, and the scheme has to be straightforward, otherwise it's unworkable. But the problem is, with Jersey's scheme, this 3-year rule, is that it sort of, unfortunately, in my opinion, discriminates against people who've been sexually abused as children, because if you think about it, lots of people who've tragically been abused as children don't come forward for many years, if not decades. And by the time they do come forward, they can find that time limits prevent them from accessing justice. So, it's open to a survivor of sexual abuse to make an application to the Criminal Injuries Compensation Scheme to get compensated for the consequences of the crime that they were subjected to. But the problem is that they can find themselves being rejected because they didn't apply within 3 years. And that 3-year period would have started to run on their 18th birthday. So by the time they come forward in their 30s, 40s, 50s, whatever, they're too late. And it's very unjust, in my opinion, because the reasons for the delay are all intertwined with the actual crime. It's the crime that they experience as a child that prevents them from coming forward in a speedy fashion, if I can put it like that. The damage is such that they just can't,
Obviously, one of the problems, it could be an extra problem, because a lot of the people could be dead after a period of passing of years, couldn't they? So that makes it very difficult to establish what the crime was and if it was a crime at all.
That may well be so, but lots of victims have come forward, and the police have been able to successfully investigate, and there's been successful prosecutions, and the offenders have been, convicted and sent to prison, and then the victims are sort of left high and dry, so to speak. The criminal court hasn't made...
Why doesn't the basic criminal compensation fund allow for this? Why doesn't it? What's the problem there? The basic fund?
The problem is the terminology of the scheme. It's the scheme's rules. The scheme says, you should have applied, within 3 years. Say 3 years of you becoming an adult when you turned 18. Therefore, in theory, you should have applied by the time you're 21. And that just, in this modern age, doesn't work. It might work for, say, if you've been the victim of a mugging, you've had some bones broken as a result of being robbed, you can understand why you should get on and apply within 3 years. But when you're a youngster and you've been subjected to, the horrendous crime of sexual abuse, it's totally unrealistic to expect them to come forward by the time they're 21.
It's strange that this wasn't all picked up, because when the rules in Jersey were relaxed on corroboration, because obviously unless there was corroboration it was very difficult to bring a prosecution at all, but once they seem to have relaxed that, I'm not saying it's no longer a factor, but you'd have thought that this would have automatically followed from that, wouldn't you?
Very good question. This has been a problem that I've learnt about, that's been knocking around for a long, long time. It should have been dealt with ages ago, and it's very unfair and unfortunate that there are people in Jersey who have been sexually assaulted as children. They've done the right thing. They've gone to the police. They've given evidence. The abusers have been convicted, sent to prison, and so on. Yet they're then told, sorry, you're too late. That just doesn't sit right with me. That seems very unfair. It's almost immoral in a way. It's just plain wrong, and it should have been dealt with a long time ago, and it needs to be dealt with now.
In a somewhat different area of activity, I know that architects and architectural designers, they were kicking around the question of liability years ago. And at one stage it was such that the defects liability period for bad design or whatever runs from the time by which the defect is discovered. And that caused a lot of worry to architects that they could be sued, or their widows could be sued, because defects only appeared at a certain time. But if you call it not exactly a crime, but then the bad design was done many years before.
Yeah, it's a latent issue. And of course, in civil law, so we've been talking about Jersey's Criminal Injuries Compensation Scheme, which is a standalone scheme to compensate, or supposed to compensate victims of crime.
Right.
What you're talking about is limitation or prescription, which applies in civil law. And again, there are problems here because you get the same sort of issues. Victims, survivors coming forward many years after they've been abused, and they want to take action against whoever's responsible, and they find that they can't because they are, as we put it, time barred. Lots of jurisdictions, Commonwealth jurisdictions, where their law has been based on English law for decades, if not centuries, so English law is you have a limitation period of 3 years, although the English courts have a discretion to disapply. A lot of Commonwealth countries have gone in the direction of actually removing these limitation periods for victims of sexual abuse. So if you look at Australia, so each Australian state has its own laws, which are all modelled on English law, but they have, as a result of the recommendations made by the Royal Commission in Australia, radically reformed in quite a number of the states now, so that limitation itself isn't used as a defence or a barrier to prevent victims seeking justice. Scotland has recently followed the law, as I understand it, in the state of Victoria, and so for victims of child abuse, the limitation period has gone full stop. So, in Scotland and Victoria, victims are able to come forward, and they are not impeded.
Right. Where does the money come? Where does the money come from? Does it presumably it's not come from the perpetrators?
It can do.
Can it?
I bring cases against perpetrators. Perpetrators should be the first port of call, and lots of jurisdictions, including Jersey, if I'm not mistaken, the courts are supposed to make what's called a criminal compensation order when the offender is convicted, found guilty, and convicted and sentenced. The offender is supposed to pay compensation to the victim.
But the fund, all I can say is the fund had run very dangerously short of funds, and they were hoping for.
Offenders should be paying for the enormous damage that they cause.
If they haven't got any money.
There'd be a long conversation for us to debate why courts aren't making use of these powers, but they're not, basically, when it comes to victims of sexual abuse. Moving on from there. So, yes, offenders should pay, and I bring cases against offenders. But sometimes there's bodies that are responsible for what was going on, where it's,
Now, in famous cases,
the Catholic Church or
Right.
the authority,
Right.
some sports organisation. If these organisations want the benefits of having youngsters coming through the doors for whatever reasons, they've also got to take a share of the responsibility, and that is why courts, will on occasions order these institutions, these bodies, to pay compensation to the victims.
I'm not aware, I don't know whether prosecutions took place, but in certain famous celebrity cases, there were certainly, some of them were dead, the celebrities were dead, but their estates were still having to pay out.
Yeah, there are lots of situations where, sadly, victim survivors cannot obtain compensation.
Right.
And very often I have to advise people, I'm sorry, but there's no way that you can proceed with this for whatever reason. There are lots of legal and practical barriers but prevent people from getting access.
Would it be appropriate for the government to pay out in those cases, to find the money? Would it be appropriate or not? To compensate people?
There are many situations where, sadly, victims, survivors cannot, and it doesn't matter what inquiries you pursue and what steps you take, it's going to be a futile exercise. But there are cases where offenders should be made to compensate, and there are cases where those responsible for the offenders should compensate.
I don't want to run up your expensive telephone. This is your telephone bill.
Very important because, I think it's a long recognised principle that stale cases should not come before the courts, because it's very difficult for a court to assess stale evidence. But the law, as it is, shouldn't simply be used as a sledgehammer to try and smash otherwise good cases. Yes, there are cases where it is going to be inappropriate for a claim to be pursued because the evidence is missing, it's stale, or it just wouldn't be right. But there are many cases where the limitation law is used, or law of prescription is used, because it's there without merit, if I can put it like that.
Can you refresh me what happened in the Jersey example? You brought dozens and dozens of cases where youngsters, long time after there were some prosecutions, but not many, but compensation was paid out to a large number of people. But the rule was relaxed in that instance. Well, that was
no, not as such. So where Jersey's had the redress schemes, they have been established outside that legal arena, so to speak, because that was the right thing to do. If these cases had been tried before the courts, there would have been no doubt all sorts of arguments about limitation, perception, liability, who did what, and all the rest of it. That would have been very unattractive all the way across the board, I would have thought, and would not have done anybody any favours. So, the redress schemes are steps being taken outside that sort of conventional legal arena, and that was, in my opinion, easy for me to say, the right thing to do, because the alternative would have been very hard for everybody.
You could, I suppose, have a permanent redress scheme, couldn't you, to allow for that to happen, couldn't you? You could do that.
Well, I find, yes, you could, and the problem is, though, that somebody has to pay for it, and there's an argument that says that yes, you should, and then there's the counter argument which says, well, you can't have this open-ended. There's no easy, to be frank, there's no easy answer to that. Where these compensation schemes have been set up in the past, it looks as though they're going to be fair and generous, and then because of financial pressures, the rules get changed, it's made harder, and then people get upset and dissatisfied, and then the scheme ends, and then a couple of years later another scheme has to be created, and so on. It all gets rather complicated.
I have to ask you...
So if you go off to Australia, for example, where there's this sort of national compensation scheme, there's lots of dissatisfaction because people are saying it's taking too long, and certain parties that ought to be contributing to the cost not contributing, and so on. It can get very difficult.
I have to ask you, which I always ask you, why is Alan Collins, an English lawyer, having to do this now? Why isn't a Jersey lawyer or a Jersey politician pushing this amendment?
Well, I'm hoping that Jersey's politicians will do the right thing, and they'll get this, what I see, gross injustice sorted out once and for all. It's been on their desk for a long time. I didn't know that. It's only when victims start knocking on my doors out of frustration that I discover what's been going on, and I will do whatever people want me to do.
Children's rights.
If saying help me, I try and do my best. Sometimes I can help, sometimes I can't. But this particular issue, Jersey's criminal injuries compensation scheme, is long overdue for some simple reforms. Not rocket science. They just need to, remove this else, well, yeah, so be it. But as regards, this particular group of people who've been let down in the worst possible way, it's now time for Jersey's government and politicians to put matters right.
Of course, children's rights are supposed.
Make it a little bit fairer.
Children's rights are supposed to be the number one top priority on the programme, but they're obviously not, are they?
Well, this is, as I said, in my opinion, the scheme as it is discriminatory. It discriminates against victims of childhood sexual abuse, and I do not see how that can fit with Jersey saying that it wants to meet, international obligations and standards and so on, which is all very laudable. But if you've got this scheme that isn't delivering for victims of childhood sexual abuse, then the rhetoric doesn't match the reality.
Thanks for your time. We will stop the interview there. If you'll hang on the line, I want to have a word with you about something else, but I'll stop there.